Hello, good morning, and welcome to Unacademy IAS, a one-stop destination for all the English medium civil services aspirants. Welcome to another session of Hindu news analysis. And from today's newspaper, I've taken all of these articles for the discussion. What are the list of the articles? We'll start with the first article, that is ANI versus OpenAI. And don't worry about the date, it is 11th December 2024. So the first article will be ANI versus OpenAI. Then certain very important reforms proposed by UGC. What are the important points there? Third one will be Code of Conduct for Judges. There is an article in the first page. There is also a very big article in the text and context page. We will discuss that. Then there is one more article, SC seeks details of speech by the High Court judge related to the third article. Removal of Vice President, let's say a motion has been submitted, a letter has been submitted in the Rajya Sabha by India bloc seeking removal of Vice President. What are the issues involved there? We'll understand. Next, the Subramania Bharati writings have been released by Prime Minister. PVTs and PM-JANMAN Yojana, space program, there is an editorial on this. There is also a very important article, very small article regarding AYUSH Visa. Then the 10th article that I'll be discussing will be again one more initiative, PM-POSHAN. And in addition to all these 10 articles that I've taken from Hindu newspaper, I've added one more article from Hindustan Times, that is India is defending its a fishery subsidy program under WTO. So these are the 11 important articles that I'll be discussing today. Before I start, the journey from an aspirant to a civil servant generally takes more than 1 year. For some people it is 15 months, for some people it is 16. But if you talk to any of the topper, you will realize that you will have to spend around 1+ year in order to become a civil servant. Now, in order to assist you, we have a program. If you subscribe to the English program or any of the courses, for 9 months, we will provide you free extension. I repeat, if you subscribe to any of the programs under Unacademy, let's say you purchase subscription where you will watch the English classes, and if you get a subscription for 9 months, we will provide you an extension of another 9 months. So totally 18 months. And if you purchase subscription for 12 months, we will provide you an extension for another 12 months. So this particular initiative has been launched, and this is available for a very limited time period. If you want to avail this, let's say extension of 9 months or 12 months, all you need to do is, when you're adding this particular program to the cart, you need to use the coupon IAS English. Type the coupon IAS English and you will be getting this particular extension of 9 months, 18 months or even 12 months according to the program that you have chosen. This is available for a very limited time period. Use it. Now let me start the discussion. The first article, an editorial, the significance of ANI versus OpenAI. What are the important points? Let's try and understand. In India, for the first time ever, I repeat, in India, for the first time ever, there is a case which has been filed against OpenAI. And what are the important points which are mentioned in the article as well as in the case? Point number 1, there is an agency by the name of ANI, that is Asia News Network. Asia News Network. So this particular company or the agency Asia News Network approached Delhi High Court and has filed a case against usage of the information or the copyright material of ANI, which is being used by OpenAI. Now what is the issue here? The OpenAI, let's say it has multiple tools which they have developed and they are developing. For example, ChatGPT. Whenever they are developing these models, they will use a lot of information that is available in the internet and train these models. And when you use these particular information, let's say agencies such as ANI, which has put out a lot of, let's say, newspaper articles, lot of information, etc., they claim that they have a copyright. They have copyright ownership over this. And whenever somebody is having a claim of copyright, without their consent, you are not allowed to use that information. So the three very important issues which have been raised by ANI in their filing to the court are: one, the ChatGPT, or let's say the OpenAI, they are simply using the information that is published by ANI without taking any kind of a consent, without taking any kind of a, let's say, without providing any kind of information and without taking any kind of permission. So the argument is they are violating the copyright law. They are simply violating the provisions of the copyright law. The first very important issue. Second very important issue, there is a term called as hallucination. Whenever you talk about OpenAI, or for that matter any artificial intelligence, there is always a concern regarding the concept of hallucination. What do you mean by hallucination in this context? If you give a prompt, let's say you will ask something in ChatGPT, and the ChatGPT will give you information, and they will give you that this information is taken from a particular source. What if this source is not correct? For example, you type something and let's say they will quote Hindu as a source of this information. What if the Hindu newspaper simply says, I did not publish this. I don't know from where the ChatGPT has taken this information, but they are wrongly attributing this information to me. And this becomes a problem if the information that is provided is not correct. If the information is, let's say, insulting someone, if the information provided is against national interest or something of defamatory in nature, if this is attributed to Hindu, then automatically Hindu has to come out and say, this is not what I said, this is not what I've published, etc. So the second concern which has been raised by ANI is the information that is provided is wrongly attributed to me, and this will damage my reputation. It will simply destroy my reputation in the market. So the second concern that has been raised is the issue of hallucination. And the third concern that ANI has raised is, in many cases, the OpenAI will take the information not directly from me, but from some other sources. But what does ANI do? ANI essentially works like a syndicate. Right? It is basically a model of a syndication where information is collected by ANI, and this information will be used by multiple, let's say, newspaper publications, will be used by media outlets, etc. Now, what if the OpenAI will take information from this source, and this source has taken information from ANI? So basically what OpenAI is doing is, it is scraping the information. It is collecting information from multiple sources, and these sources in turn are collecting information from ANI. So that is a third concern which has been raised by the ANI in regards to the functioning of OpenAI. So I hope all of you have understood what are the three very important issues or concerns raised by the ANI in its, let's say, the case which it has filed against the OpenAI in Delhi High Court. Now, what are the arguments put forward by OpenAI? What are the arguments, counter arguments? The counter arguments are as follows. Point number one, OpenAI simply says the servers are located outside India. Whatever information we get from, let's say, ChatGPT today, you type something, you give a prompt to ChatGPT, and it will give you certain information. The information is taken from a server, and this server and the work associated with these models are done outside India. So the first contention of the counter arguments put forward by OpenAI is, it is not within the jurisdiction of India. It is not within the territory of India. So there is no jurisdiction in India. It shall be taken or it has to be taken outside India. That's a point number one. Point number two, the ANI approached Delhi High Court and sought an immediate stoppage of all the data that OpenAI is using from these sources. That is either directly from the ANI or indirectly through other sources which are using ANI. So ANI approached Delhi High Court and sought a stoppage to access to this kind of information which is allowed right now, which is there right now for OpenAI. Now OpenAI simply stated that this is not the first time that such concern has been raised. The same concern has been raised in USA, Canada and Germany, and the same issue is there in many other countries as well. And there are multiple petitions or multiple cases which have been filed against OpenAI in many other countries. But the contention is simple. In none of these cases, which are older now, in none of these cases, there is no stoppage, there is no injunction which has been provided by the court against OpenAI. In simple terms, OpenAI says, you want to take up the case, you want to hear both the sides, here. That will take a long period of time. But right now, immediately you cannot pass an order stopping me to get access to this kind of information. So immediate relief or immediate stoppage should not be provided. That is the second contention raised by the OpenAI. Third contention, their argument is ANI is claiming copyright law. They are simply saying we are taking the information and we are violating copyright law. But the contention is you can claim copyright over the information that you have provided, but you cannot have copyrights over facts. You cannot have copyrights over ideas, etc. Fourth point, OpenAI simply says, whenever I take some information from, let's say, ANI or let's say any other source which is getting its information from ANI, we do not simply take it and give it to a user. I do not simply copy and paste the information that you have provided. I generally work on the information. For example, how these AI systems work. For example, if you ask how a system or let's say how a technology works, the OpenAI would have collected information from multiple sources, would have reworked the information, would have reworked on the statements, phrasing of the statements, etc., and then compile the information and give it to me. So their argument is we are not simply copying and pasting. Right? That is your contention. That is what ANI is saying, that the OpenAI is simply copy and pasting my information. But OpenAI simply says no. There is something called as a transformative law or a transformative principle, which is usually used in United States of America. According to the law there, whenever you use this information and you transform the information, you rewrite all the paragraphs, you rewrite the statements, etc., which is distinct from what is the original source, you cannot claim a copyright over the second one. The first one cannot claim copyright over the second one. So that is essentially the concept of a transformative principle which is accepted in USA. So the OpenAI simply says, no way, whatever are the arguments of ANI should not be held, should not be taken into consideration. The court should hear all of this. And this case is very important. Reason being, like I said, this is for the first time that OpenAI has been dragged to court in India over copyright law. First time ever. And whatever is the outcome of this case will have a larger implications. For example, what if the data is stored outside India in a server which is placed outside India? What kind of provisions in India's copyright law are applicable on it? Second, although in this case, that is ANI versus OpenAI, the discussion is surrounding the copyright law, there are many other issues which are being discussed, not in this case, but in other cases in other countries. For example, in many countries, OpenAI has been dragged to the court citing privacy issues. And that also has to be taken up, or that will also be one of the parts of the discussion in the coming days. Point number 3. Now there is a discussion, there is a debate. Should the copyright law should be upheld? Should we take the copyright law into consideration and impose certain restrictions over OpenAI? If you do that, then the AI usage will become limited. The amount of information that you can drive or get from OpenAI, or let's say ChatGPT, will become limited. Or else what can happen is, if ANI's arguments are held correct, then the ANI might start charging certain amount of money to OpenAI to get access to their information, which is done in many other countries right now. And if ANI will start charging the OpenAI for getting access to their information, then the ChatGPT services, a lot of which is available for us at free of a cost, might become costlier. There might be limitation on how much usage is allowed, etc. So there is a larger implication associated with this particular case which is being heard in the Delhi High Court. Now what has the Delhi High Court done? The Delhi High Court has stated, this is a very technical issue, so they have appointed an amicus curiae. And they have appointed amicus curiae to assist the Delhi High Court. And point number 2, the next hearing has been posted in the month of January, last week of January. So these are certain very important points regarding the central page article, which is talking about ANI case against OpenAI. Okay. Now, in addition to this, there are 2 very important principles which are mentioned in the article. Suddenly, UPSC might ask you a question on it. The first principle is permissionless innovation. Permissionless innovation. And the second principle is a free inquiry. Remember this. One is permissionless innovation and the second one is free inquiry. What are these 2 principles? The argument of the authors is the free use, the fair use, not free use, the fair use principle. And in recent times, the fair use principle has been cited multiple times in the newspaper regarding critics which are done, or let's say the critics of the movies which are posted on the YouTube as such. In many of the cases you must have seen, the critics are posting one more video saying that my video has been taken down. What is the reason? The critic was critical of, let's say, a particular movie, and the directors and the producers of the movie will approach YouTube. They will write to YouTube saying that there is a copyright violation. And the YouTube will basically strike down or take down a video of a creator. In that particular context, again, there is a discussion of fair use. So remember this, in India's Copyright Act, there is a provision which basically facilitates a fair use theory or a fair use principle. Fair use simply means you are using certain copyright material for, let's say, critiquing, for, let's say, developing something, or for educational purposes, etc. That is essentially called as a fair use principle. And the fair use principle functions on 2 more principles which are called as permissionless innovation and free inquiry. What is a permissionless innovation? You should allow innovation of anything in the society as long as it doesn't harm the society. I'll repeat the statement. The term permissionless innovation simply means any innovation that is going to take place, you should allow it to happen as long as it doesn't harm the society. And the second, the free inquiry essentially means the availability of a data. Whenever data is available, it should be made accessible to the public free of a cost, or accessible in order to use it for scientific purposes. So these are the 2 more principles which are mentioned in the article. Please be very, very careful. Okay. Now, based on this, I have given an MCQ. Consider the following statements. The Copyright Act in India provides for fair usage of copyright material. The Copyright Act in India explicitly provides for transformative use of copyright material. Which of the 2 statements are true? If you know the right answer, please do let me know in the chat section. If you do not know, don't worry, I'll discuss it at the end. I've also given a mains answer writing practice. The rise in technology in the form of AI has thrown up new challenges related to data protection, privacy, copyrights, etc. Discuss the above question for 250 words. Please do try it. Next, reforms which have been proposed by University Grants Commission. Although this has been given in a very small sized article, when you talk about education reforms in India, this becomes very important. Now, what are the important points here? Let's try and understand. University Grants Commission is a statutory body which has been functioning from 1956. The importance of UGC is that whenever you start, right, let's say applying for the undergraduation or post-graduation, how the courses will have to be formed, what kind of courses will have to be provided, what should be the duration, what should be the standard of, let's say, education, standard of, let's say, institution, etc. All of it comes under the University Grants Commission. Now, multiple reforms have been announced by UGC earlier, but this new reform has raised certain eyebrows, and it's a very important set of reforms. What are the important reforms? Let's go one by one. Point number one, the new reforms announced by UGC have proposed new type of graduation programs. For example, right now, if you enroll into graduation, let's say you want to become an engineer. The graduation program is for 4 years, correct? It is for 4 years. You want to get a degree in BSc, Bachelor of Science. That degree is given for after a duration of studies that you do for 3 years. So there are certain graduation programs for 3 years. There are certain graduation programs for 4 years. But the contention of UGC is that why should we have a rigid structure like this? Why? Because the global standards are different. Why not allow somebody who is a slow learner, who has certain issues, who wants to take it, right? Let's say one step at a time, wants to take it for, let's say rather than 4 years, 4.5 years or 5 years, why not provide that kind of a flexibility? And on the other side, there are certain people who learn very quickly, who have certain compulsions, who want to finish it in a shorter duration. They want to have a graduation course. So rather than sticking to this concept of 4 years, 3 years, why not provide flexibility? And that's a precise reason under the proposals, and mind you, these are proposals. These are expected to be implemented by respective universities or institutions in the next year. And these are not compulsory, by the way. I repeat, these are not compulsory. These are basically proposals put forward by UGC. If a university wants to adopt it, they can adopt it. So the argument of UGC is very simple. Let's provide flexibility rather than having it for 4 years. Can we allow certain students to take this graduation for 5 years? And rather than doing it for 4 years, can we reduce it to, let's say, 3.5 years and allow them to finish off the graduation within 3.5 years? This kind of a flexibility has been provided. And those who are wondering, how can this happen? Sir, I should complete all these subjects, etc. My dear, in such cases, the UGC simply says, instead of taking, let's say, I'll take a hypothetical example here. Instead of taking 5 subjects in every semester, if you want to finish it sooner, can you take more than 5 subjects in these semesters? Right? For example, if you are supposed to take, let's say, 5 subjects in the second semester, instead of 5, you can opt for 6 now. You can opt for 7, so that the number of subjects you can cover much faster and the graduation can also be completed rather than in 4 years, let's say 3.5 years. So that kind of flexibility is being provided under the new proposal. Point number 1. Point number 2, generally when the admissions happen, these admissions take place once in a year. There is a cycle for admissions. So these admissions happen once in a year. Now the UGC simply says, why not have it 2 times in a year? Let's say once you can have it in the month of January, and second you can have it in the month of June and July. that will provide a lot of flexibility for the students as well as for the universities. If you want to, right, basically provide more seats, you want to have more enrollment, you can do that now. So that's a second proposal. So 2 admissions, 2 cycles of admissions. That is the second very important proposals. Third very important proposal, there is a concept of entry and exit. Right? What is this idea of an entry and exit? Let's say I'm pursuing a graduation. Let's say I'm pursuing engineering graduation, which means for the next 4 years, if I start today, for the next 4 years, I can't do anything. What if there is some emergency in my family? What if I want to, right, enroll into one more course during this particular period of time? What if I want to do 2 years now and later do 2 more years? That kind of facility right now is not available in many of the institutions in India. That is the reason in the national education policy, most of these proposals have been taken from national education policy. So what is the proposal here which is being promoted by the UGC now? You can, let's say, do a 2-year course, then take a break. You want to enroll into one more course, do it. And after a couple of years, you want to come back and finish the next 2 more years rather than starting from the beginning. I hope you understand. Rather than starting from the first year, can you basically pick it up from the 3rd year? That is allowed, that is being promoted by UGC. Entry and exit. Entry and exit. And this is one more very important proposal. Fourth very important proposal, hybrid learning. Hybrid learning, and you can enroll into multiple, let's say, the divisions now, or multiple, let's say, different types of subjects now. Meaning what? Until now, the education has been focused on going to college, going to university, sitting throughout the day in the university, attending classes. But the national education policy basically promoted this idea of a hybrid learning. For example, one point of time, right, let's say I'm enrolled into BTech, at the same point of time, I also want to get a graduation in another area, another domain altogether. Right now, it is not there. But the UGC now says we should promote that as well. We should promote that. And we can use the hybrid model to actually promote it. What is the hybrid model? Let's say I'll go to college in the morning. I'll come back in the evening. And in the evenings, I'll attend classes for one more, right, let's say a segment or one more graduation. So that should be done online, or that can be done online. So this kind of a hybrid learning is also being promoted now. Right, this is one more proposal. Next, fifth very important proposal. I'll come back to what is given in the article later. Don't worry, I'll discuss that also. Fifth very important proposal. I know pretty much most of you would have seen this and some of you would have experienced this. That is, whenever you want to apply for exam, right, let's say in the graduation, you need to get the signature, right, proving that you have attended certain number of classes. I have also faced a lot of issues during my days of graduation, where you keep on running behind certain, let's say, heads of the departments, and the heads of the departments will open the attendance register and tell you that you have attended 60% of the classes, I cannot sign. Get permission from somebody, etc. So now UGC simply says, rather than having a fixed requirement of attendance, can we allow the universities to determine whatever the minimum required percentage of attendance that the university wants? So there will be flexibility provided in terms of university determining its own attendance policy. Is it okay? The university will determine its own attendance policy. That's a fifth very important point. And the sixth one, right now you want to, let's say, once you enroll into 11th and 12th standard, you'll have to focus on statistics as one of the very important segments for you, or one of the very important areas of subject, or you'll have to focus on the chemistry, maths and biology if you want to enroll into a particular, let's say, studies later, etc. So the argument of UGC is, right now there is a concern that you want to enroll into a certain graduation, you will have to have the knowledge regarding the subject, you will have to do the studies before that in similar subject. Why should we have it? Can we allow somebody who has learned, let's say, the science, somebody from a science background to enter into the MA stream? Can we do that? Can we allow that rather than simply restricting it like this? So that is the sixth very important proposal. The UGC has stated that we should have a national level exam. We should have a national level exam. And once you attend this exam and get through the examination, now you will be given a choice. You want to pursue MA, you can do that. You want to pursue, right, let's say commerce, you can do that. You want to pursue, right, XYZ stream, you are allowed to do that even if you do not have, right, let's say studied a similar stream before this graduation. That is also, right, one more proposal of UGC. So these are the 6 very important proposals that have been put forward by UGC to streamline, to make the system of education, graduation and post-graduation in India on par with the global level, to provide flexibility, etc. Now, what are the concerns? I have told you what are the advantages while discussing the 6 proposals. But what are the concerns associated with this? And that is exactly what is being discussed in the article here. The concerns are as follows. Point number 1, already many of the universities with only one cycle of admission, they are finding it very difficult to conduct the whole administrative process. I'm pretty sure you must have gone through the grinding process of getting admission into a college or a university. They are doing it only once in a year, and that itself has become a headache because the process is not streamlined. They may not have sufficient number of people working in the offices, etc. They will not be able to handle the number of applications. So with only one admission cycle, there is so much of chaos which is present. Now imagine they will shift to 2 cycles of admission. So administrative wise, it might become very, very difficult. Administrative wise, this might become very, very difficult. Point number 1. Point number 2, you are basically asking the universities to determine if they want to have this kind of a policy. That is, it is not compulsory. Universities will take a call. But don't you think a lot of these universities and lot of these other institutions, they are government funded or government run colleges? Government funded or government run? And when you have government run colleges, there is already a problem with the number of teachers. You generally do not find sufficient number of teachers. If the teachers are there, these are not very well dedicated to, right, improve the situation of the students. You will find it very difficult to get access to quality education, etc. So there is already problem from the supply side. Now you want the same institution to adopt these kind of reforms, where they will allow exit and entry, where they will allow, right, there's a concept of ABC, and that is academic backed credits. There's a concept of ABC which has been proposed. And rather than having full-time course like this, 50% of the credits you will get from your, let's say, subjects, and remaining 50% you can do an internship and get it from there. So the question is, how do we implement all of this? If you create a system of ABC, that is backed credits, who is going to manage it? Who is going to implement it? Because the argument is, education right now basically is a subject under the central government as well as the state government. Many of the times, state governments initially are very enthusiastic. They will implement these policies, but later on, they will backtrack. Later on, they'll simply say, I do not have sufficient funding. I do not have sufficient manpower, etc., etc. And they'll start the implementation of these policies in a very relaxed way. In such cases, don't you think the policies which are very good, the proposals are very good, on line with international practice, but the implementation will become very difficult. Implementation will be very, very difficult. And the fourth very important concern is, if you want to achieve all of them, don't you think you will have to spend a lot of money? you will have to spend a lot of money. You'll have to invest a lot of money, right? Let's say the governments will have to spend money in developing infrastructure. The center has to allocate more amount of money whenever the budget is presented, etc. But right now, the allocation for education compared to last year, the allocation has been reduced. So the concern is, what about the impact on the government finances? What about the impact on government finances? You'll have to take those also into consideration, because these policies will definitely have an impact on the government finances. Done? So these are some of the very important concerns which have been mentioned in this editorial in the Hindu newspaper titled Ends Without Means. So I've given you a wholesome discussion here. The only idea is to ensure that you know what is the background to this particular editorial. You should understand the recommendations first, proposal first, and then you will realize what are the criticisms which are provided in the article. So the whole idea is to give you the wholesome or all around information regarding all the current affairs events. And if you like all of these initiatives, do not forget to hit the like button. And if you're yet to subscribe to our YouTube channel, kindly do it right now. Now I've given an MCQ regarding this. Consider the following statements regarding UGC. UGC is the statutory authority set up in 1949. UGC provides a financial assistance to certain educational institution, is responsible for the implementation of EPG Pathshala. How many of these statements are true? If you know, please do let me know in the chat section, or else wait, I'll discuss it at the end. The next article, Code of Conduct for Judges. In the last couple of days, there has been a lot of discussion because of statements which have been reported to be said by a Justice of Allahabad High Court. Various newspaper articles have reported saying that some of the statements which were given by this particular judge were not in good taste, were targeting certain sections of the society, and a judge or a sitting judge of a high court should not have said these kind of statements. Ethically, these are wrong, and these will cast a shadow over unbiased approach of judiciary. Now, what are the important points mentioned here? Please understand these particular points. Although a lot of discussion is around the rhetoric, around what the judge has said, do not focus on the noise, focus on the news. What are the important points? I want you to understand these points. First one is, whenever you talk about the ethical code, ethical standards that the judges will have to maintain, will have to basically opt for, there is no legal document in India. That is, Government of India has not passed any piece of legislation. There is no act which talks about what should be the stand of the judges, how the judges should basically conduct themselves, what are the ethical principles that they are supposed to follow. Although there was a proposal earlier, and remember this particular point, earlier back in the year 2010, Government of India proposed a bill by the name of Judicial Standards and Accountability Bill. Judicial Standards and Accountability Bill. This particular bill, which was proposed or introduced by the government back in the year 2010, spoke about the ethical standards. What kind of principles the judges should follow, what are the do's and don'ts, etc. This was introduced by the government in 2010. There was this was referred to a standing committee. It was passed in Lok Sabha. Then it was sent to Rajya Sabha. So far, there is no discussion regarding this. Right? The Rajya Sabha has not taken this up for discussion. So basically, this was there earlier, more than a decade ago. Right now, what is happening regarding, let's say, the conduct of the judges in many of these instances gives a rise to a demand for these kind of proposals. Now, what are the important points? Point number 1 and point number 2, please remember this. Right now, like I said, the Government of India doesn't have any piece of legislation which will control or which will basically direct the ethical conduct of the judges. But instead, Supreme Court of India, back in the year 1997, adopted a basic document by the name of Restatement of Values of Judicial Life. This has been mentioned in this article as well as the article in the first page. So remember this. It has proposed and adopted a document by the name of Restatement of Values of Judicial Life. If you look at the document, there are 16 points. I repeat, in this document, there are 16 points which are directing how the judges should maintain themselves. Whether you are in public or in private doesn't matter, because the last point in this document, 16th point, says whether the judge, Supreme Court or High Court, doesn't matter. Whether they are there in the public domain or private domain, they should always remember they are under the watch of the public eye. They are under the constant public gaze. So they should conduct themselves so that there are no questions raised, there are no doubts raised regarding the conduct of the judiciary. In fact, the first point in the document itself says, whatever be the act of the judges, it should lead to a conclusion in the eyes of the public that they will believe that judiciary is working, judiciary or justice is being done. Whatever you do, this should always lead to this particular agreement in the eyes of the public. And what the author in this article simply says is, whatever is being discussed currently regarding the justice of Allahabad High Court is against these principles, is against these moral values, or let's say the points which are provided and adopted by the Supreme Court and which are to be implemented across all the levels of judiciary in India. This is point number one. Point number two, is there any other document which talks about ethical conduct of judges in India? There is one more. Please remember this. The Bangalore Principles of Judicial Conduct 2002. What happened back in the year 2002 was, there was a conference of Chief Justices. There's a conference of Chief Justices, and these Chief Justices put together, they agreed on a particular document which talks about ethical conduct of the judges. And this particular document last year also was there in the newspaper discussion. Reason was essentially there was a referral done by Chief Justice of India regarding the conduct of one of the judges in West Bengal. So basically this is one more point, the Bangalore Principles of Judicial Conduct. And the Bangalore Principle of Judicial Conduct talks about 6 very important ethical values or the principles that all the judges should maintain. Independence, impartiality, integrity, propriety, equality, competence and diligence. This is the 2 very important points or 2 important documents that talk about ethical conduct of judges. Point number 3, there is also discussion in the article regarding impeachment of Supreme Court or High Court judge. Although I have written Supreme Court or High Court judge, in this case, it is more to do with impeachment process of a High Court judge. Basically, argument here is the High Court judge can be impeached on 2 grounds. That is, there is a proved misbehavior on part of the judge, and same argument for Supreme Court judge as well. Second one is incapacity. The judge is not in a right capacity to conduct and perform the duties right now. So on these grounds, a judge can be impeached. There is a particular process. The motion can be introduced either in Lok Sabha or Rajya Sabha. In Lok Sabha, 100 members have to sign. In Rajya Sabha, 50 members have to sign. Once the motion is passed in one of the houses, will be sent to the second house. Again, it will be discussed and passed in the second house. Then the motion, or let's say the order, will be sent to the president, and the president shall issue an order removing or impeaching a particular judge. That is essentially the process. But in addition to this, the article also says, rather than conducting a very lengthy process like this, it's a very lengthy and taxing process. In order to cut short, or in order to provide one more way for judges, there is one more process which has been adopted by Supreme Court. This process has been adopted by Supreme Court back in 1999, and the information regarding the process was put in a public domain by Supreme Court in 2014. What is the process? let's say conduct of a particular judge has been questioned and a complaint regarding this is submitted either to Chief Justice of the respective High Court or the Chief Justice of India. Now there will be an inquiry conducted. The report will be sent to Chief Justice of India. Chief Justice of India will look into the inquiry and will ask a particular judge or judge in the question to resign. If the judge in the question doesn't accept it, will protest against this, then the CJI will submit or will simply forward this particular report along with the complaint to the President of India. And the earlier process that I discussed will be carried out. The argument is simple here. Rather than the first step to be an impeachment process, which is a time-consuming process, which is not an easy process because both the houses are involved here. This new process has been introduced by the Supreme Court of India. And that is the third point which has been discussed in the article regarding impeachment. And this discussion regarding impeachment of a High Court judge has come into question because of the statements given by the respective judge here. Right? Because of the statements given, many of the critics are demanding that this particular judge has shown a biasness, has shown that when he will provide rulings or he will order something, he will not do with impartiality. Hence, the person should be impeached. Done? So, these are certain very important points regarding the article provided there. Next article, there is a motion in Rajya Sabha which has been submitted to the Deputy Chairman now, calling for removal of Rajya Sabha Chairman. Calling for removal of RS Chairman. What are the important points? Although the article discusses simply these are the allegations against Mr. Dhankar, etc. Don't worry about allegations. UPSC will not ask you about allegations. What are the important points? The process, the articles which are connected to the process. The Vice President of India by default is the de facto chairman of Rajya Sabha. He oversees the functioning or the proceedings of Rajya Sabha. Now, there are multiple articles, but because the article given here in Hindu newspaper as well as many other newspapers is discussing the removal of the Rajya Sabha chairman, the article that you need to remember are two important articles, Article 67B and Article 92. Article 67B and Article 92. And again, I am repeating it. There are many other articles which are connected to the Vice President of India. But this article is discussing only the removal of the chairman of Rajya Sabha or the Vice President. I want you to remember the two very important articles, 67B and Article 92. Article 67B talks about removal of Vice President. Although they are talking about the chairman of Rajya Sabha, it is Vice President. So what is the process? The process is very simple. First, a motion has to be introduced in Rajya Sabha. It has to be in Rajya Sabha because the chairman of Rajya Sabha is the Vice President. So it has to be introduced in Rajya Sabha, but with a notice of 14 days. Remember this, with a notice of 14 days. That is, once you introduce the motion, it cannot be immediately discussed and adopted. No, there will be a period of 14 days before the discussion has to happen. So 14 days notice period has to be provided. That has been given now. And many of the experts are saying this is just symbolic. There is not going to be any real outcome out of this. It is just symbolic. Reason being, today, let's say the submission has happened yesterday and Rajya Sabha, or let's say the Parliament in this session is going to work only till 20th. Is going to work only till 20th. So, even if you have submitted yesterday, the 14 days duration will be over by 25th of December. And before that, even before the 14 days are over, essentially what will happen? The sitting of the Parliament, this session of the Parliament will get over. But what is the importance? Many of the opposition party members are arguing that the importance of this motion that they have submitted is that they want to increase the accountability. They want to hold person, or let's say the Rajya Sabha chairman, accountable here. And please understand, in that context, you'll have to remember one more article, that is Article 92. What does the Article 92 say? If there is a motion which has been taken up regarding removal of, let's say, chairman or the vice chairman of or deputy chairman of Rajya Sabha, the said person against whom the motion has been introduced cannot preside. Cannot preside. Right? So the argument is, when this will be taken up, if at all it is taken up for discussion after 14 days, which is not going to happen now. So if at all it is taken up, Mr. Dhankar, who is the vice president, cannot preside over this sitting of Rajya Sabha. Cannot take part as a chairperson or the chairman of Rajya Sabha in this particular discussion. That is provided under Article 92 of Indian Constitution. So these are the two very important articles regarding, let's say, the process of removal of Rajya Sabha chairperson. In addition to that, once the motion is introduced, discussed and passed with majority in Rajya Sabha, it will be sent to Lok Sabha. It has to be discussed, passed in, right, let's say even in Lok Sabha, and then sent to President. So this is generally how the process of removal of Vice President takes place, and that is provided under Article 67. Done? So these are important points regarding the Vice President here. Next article. The Prime Minister Modi is set to release the collected works of Subramania Bharati. Important article. Why? Generally, there are questions asked from current affairs in GS paper 1, which many of the times the students say, this was not given in the books. I don't know what is the source, from where they have picked up this question, I don't know, they'll say. One such kind of a question, which is a probable question, not guaranteed, but a probable question, is regarding a very well-known freedom fighter, Mr. Subramania Bharati. Now, there are two very important points which are given in the article. Point number 1, what was the role of Mr. Subramania Bharati? Remember this. Subramania Bharati is a very well-known freedom fighter. He supported Swadeshi Andolan, a Swadeshi movement in India. He was a very well-known associate of Bal Gangadhar Tilak, and he has written multiple books. Multiple books have been authored by this freedom fighter. I have given some of the examples here. One book is The New Woman. It is basically titled in Tamil, Pudumai Pen, Hymns of Gods, Thevaram, The Song of Cuckoo, Quilpatu, etc. So these are the multiple types of or multiple books or literary works which have been authored by the freedom fighter. In addition to this, he was also very much instrumental in publication of a newspaper by the title India. Right? Remember the name of the newspaper, that can be asked in the preliminary examination. Okay. Now, in addition to this, there is a very interesting point which has been mentioned here. His writings were nationalized by the state government in 1949. In fact, this is the first kind of a nationalization of writings done by a state government. What do you mean by nationalization of writings? Understand this very carefully. I know all of you would have heard of the term nationalization in banking sector, nationalization in coal sector, etc. But I'm not talking about that kind of a nationalization. I'm talking about nationalization of literary work of an author. What are the important points here? Generally, whenever somebody writes a book or is the owner of a literary work, there is power given to this author under the Copyright Act. There are certain powers which are given to this particular, let's say, the literary author under the Copyright Act. For example, let's say hypothetically, if I write a book, under the Copyright Act, who is allowed to publish this book? I have the right. Are they allowed to publish this book? I have a right over it. Can I transfer the ownership of this book to somebody else? I have a right over it. All these kind of powers are given to authors under the provisions of the Copyright Act. But when the state government will announce nationalization, when the states announce nationalization, what does it mean? generally the state governments will purchase these, right, let's say copyright powers which are given to the authors, or let's say the after passing away of the authors, their, right, let's say the inheritors, they have the powers now. The state government will purchase this power, pay certain amount of money, and use these books for educational purposes. And whenever these books or literary works are nationalized, it simply means you can simply use this work, or let's say this literary book, to republish it, to, right, make it commercial, etc. And this is not the only case where author's work has been nationalized. There are multiple examples in the past where the state governments have nationalized the work of authors. So I found this particular point, the point much more interesting and much more important compared to the first one. No doubt, the author's work, or let's say the freedom fighter, very, very important. Please make a note of this. Question can be asked on the role of this freedom fighter in prelims as well as even in the mains. But this particular point, generally you don't come across this in the books. So please make a note of this. Okay, done. Next, there is one more editorial regarding deepening India's steps as a player in the space sector. Although a lot of factual information has been provided, let's simplify what is given here. Point number one, the space sector is one area where a lot of technology is required. And to basically promote a space sector, the government over a period of time has freed up, right, ISRO, has given a lot of funding for ISRO, and ISRO has contributed to a very great extent to the growth of the space sector in India. There are no questions regarding that. But the concern raised by the author is very simple. India wants to have a lot of, let's say, importance in the space sector. But if you want to compete with other countries in the space sector, only allowing ISRO to participate and only being dependent on ISRO might not be a right approach. I'm saying might not be a right approach. Why? Just to make a comparison, the author has compared the rockets which are used in India and the rockets which are used in USA. Very recently, this made a lot of headlines. You must have seen the rocket of SpaceX. Correct? I'm pretty sure all of you have seen this. The rocket of SpaceX, Starship, returned back to Earth. And there was a lot of discussion regarding what is the importance of this kind of a technological marvel or technological achievement. Today we are discussing about reusable rockets. That is, rather than earlier systems, right? Rather than earlier system where rocket will be used only once, now we are talking about reusable launch vehicles, reusable rockets. And if you keep on reusing the same rockets, the cost associated will automatically come down. But in addition to the reusable rocket feature, there is one more feature that is also equally important. What is the maximum payload? What is the maximum payload that a particular rocket can carry? In case of India, whenever you talk about the payload of rockets, we talk about GSLV and PSLV. Compared to PSLV, GSLV can carry a higher payload, especially the Mark segment can carry much higher payload. But ISRO is working on a new type of a launch vehicle by the name of Next Generation Launch Vehicle. NGLV, Next Generation Launch Vehicle. And according to the timeline which has been proposed by ISRO, this vehicle is under, let's say, the development stage. It will take more than 8 years now, and we will be ready with this particular NGLV. And argument is the NGLV compared to the earlier rockets, NGLV now will be reusable. It will be reusable. You can use it for multiple launches. In addition to that, the amount of payload it can carry will also be higher. How much? For example, according to the data given in the article, the NGLV can carry up to 10 tons of payload at GTO level, that is orbit level, and right up to 20 tons of, right, let's say the payload up to LEO, that is lower Earth orbit, geostationary orbit and lower Earth orbit. So you can see that the amount of payload that NGLV, which is under the development stage, it can carry higher payload and it can be used multiple times. But if you compare NGLV, which is not yet developed in India, it is in development stage. If you compare NGLV with, right, let's say the Starship rocket of SpaceX, the Starship rocket of SpaceX, the Starship can carry up to 1 lakh tons, up to lower Earth orbit, and it will be much more, it will be much more than what NGLV carry up to GTO, that is geostationary transfer orbit. It will be more than 20 tons, more than 21,000 kgs, right, when you talk about the GTO. Essentially, the argument is simple here. Essentially, the author is saying, in case of other countries, let's say USA, the amount of investment that is done in space technology is higher, but in addition to that, there is a higher participation of private sector. There is higher participation of private sector. So why don't we use the same model where ISRO will use the services of the private sector? Can we have two types of models being developed? Because after 8 years, you will say NGLV will be ready, but the spaceship is already ready. They're using it. They're conducting tests here. So why not we also speed up the same process where we involve the private sector? Because the concerns are, if private sector is there, if the private sector is allowed to participate, they may simply take certain amount of funding and they may not provide right quality of a product. There is always a concern. So in such cases, why not have a system where when they achieve certain targets, only after they achieve it, funding will be released? Why not have that kind of approach? Of course, yes, with private sector also, there is always a possibility of delays. Just like in government projects, there is always a possibility of delays even in the private sector. But the right approach that India should take now is to allow private sector to participate, contribute, and we can have better kind of technologies being invested in, developed in India compared to what we are doing right now. So this is essentially what is being discussed in this editorial on the space program in India. Next article, right, small articles now related to prelims only. AYUSH Visa. Now what is this AYUSH Visa? Certain information has been provided, how many AYUSH visas have been issued, etc. Please don't worry about it. The points are very simple. The government of India back in the year 2022 spoke about the concept of AYUSH Visa, and in 2023 government introduced the idea of AYUSH Visa. Initially it was discussed in 2022, then in 2023 AYUSH Visa model was introduced. What is this AYUSH Visa? AYUSH is an acronym. It stands for multiple components of alternative healing that are practiced in India. For example, yoga, Ayurvedic, Siddhi, etc. So many of the foreigners who are interested in, let's say, participating in yoga retreats in India, many of them are interested in getting treatment under Ayurvedic practices, etc. Earlier was supposed to take the, let's say, the normal visas and enter into India. But government of India, in order to promote the concept of medical tourism and under the punchline of Heal in India, remember this, larger initiative is Heal in India. Under the initiative of Heal in India, the government introduced the model of e-AYUSH Visa. Under the e-AYUSH Visa, there are multiple categories of visas which are provided, right? The multiple categories are provided here. Please go through that. But the concept is very simple. Rather than waiting in line and getting the normal visas, now for promotion of medical tourism, there is a different type of visa which has been introduced, right? And this model is called as e-AYUSH Visa. Done? Okay. Next, one more article or one more initiative of government. The Odisha government has approached an international organization, to borrow certain amount of money to implement a particular initiative. Second phase of an initiative by the name of Odisha Particularly Vulnerable Tribal Groups Empowerment and Livelihood Improvement Program. The first phase of this initiative has been implemented. Now Odisha government wants to implement the second phase of this. And to implement the second phase of this initiative, where they're targeting the PVTs, particularly vulnerable tribal groups, they have approached an international organization, International Fund for Agriculture Development, and they have sought certain amount of loans, and they have taken loans even under the first phase of the program. But many of the experts are arguing against this approach of the government. The argument of the experts is that, point number one, out of 75 PVTs, out of 75 recognized the particularly vulnerable tribal groups in India, 13 PVTs are present in Odisha. And because a large chunk of PVTs are present in Odisha, the central government has a program already. It has a program by the name of Pradhan Mantri Janjati Adivasi Nyaya Maha Abhiyan, PM-JANMAN Yojana. Under PM-JANMAN Yojana, the argument is, because a lot of these PVTs are present in Odisha, the funding will be provided by the government. What is such a hurry that Odisha government is approaching a foreign entity, foreign institution and applying for a loan for an implementation of a program? They will get sufficient funding under this initiative. That is the first concern. And by the way, under this initiative of the central government, please remember, there are more than 10 focus areas. I repeat, there are more than 10 focus areas. For example, housing is covered under PM-JANMAN. In fact, that is one of the central themes of PM-JANMAN. Right? That is one. Energy, skilling, right, etc. There are more than 10 focus areas under PM-JANMAN. Second concern which has been raised is Niti Aayog. Niti Aayog has written a letter to Odisha government asking certain information regarding the implementation of this initiative. They've asked, please show us data to prove what is the outcome. You have spent so much amount of money, and as a result of this, what is the outcome? What have you been able to achieve with implementation of this initiative? Please submit data to us. Rather than giving documents, rather than providing data to the Niti Aayog, in fact, please remember, under Niti Aayog, there is a office, DMEO, which generally takes care of these kind of evaluation work. So, rather than providing this kind of information, why is the state government going to an international body or international institution to borrow money? Third concern, there are certain issues raised regarding misuse of the funds, abuse of the funds. That is, the funds are being used for other purposes which are covered under the initiative. In many cases, the funds have been diverted into the, let's say, the accounts of many of the government officials, which basically means there is a corruption in the scheme. So rather than looking into all of this, right, the argument here is Odisha government is focused on something else. Done? So these are certain important points which are provided regarding the two initiatives here. Please be very careful. Next, PM-POSHAN scheme. One more initiative of the central government. Important points. PM-POSHAN is a centrally sponsored scheme. It's a centrally sponsored scheme. Under PM-POSHAN, central government will allocate 60% of the funds and the states will have to allocate 40% of the funds. And who are covered, who are beneficiaries under this? Those children who go to, right, the schools, that is essentially the schools which are aided by the government, those children who will go to Bal Vatika and the primary school children are eligible under PM-POSHAN scheme. Essentially, under the PM-POSHAN, the government wants to achieve two very important objectives. One, ensure that these children will go to government school, right? This will help us in providing education. It will help us in providing education. And second one, generally these children will find it very difficult to get access to food, because these children come from very poor households. They'll find it very difficult to get access to nutritional food also. So in order to address these particular issues, under PM-POSHAN initiative, government provides food which will consist of the pulses, vegetables as well as oil. Remember this, the pulses, vegetable and oil, right? Certain grams of pulses, grams of vegetable, grams of oil. Essentially, this will be provided in the form of meal. This is provided in the form of a meal. And remember this point as well, earlier this same initiative was called as a midday meal. The same initiative was referred to as a midday meal scheme. Later, Government of India has renamed this into PM-POSHAN initiative. Now, what is the update given here? The update is very simple. Under this initiative, I said, food is given which will consist of pulses, vegetable and oil. But the prices of these components have changed over a period of time, have increased over a period of time. In order to adjust for the rise in the prices and to ensure the scheme will be continued to be implemented and same allocation will be given to the children here. Those children who are part of Bal Vatika and those who are studying between the 1st standard and the 8th standard, they will continue to get the access to the food here, and the center has increased the funding allocation. It has increased the allocation by 425 crore rupees. They will basically take up this additional cost. Done? So these are certain points regarding PM-POSHAN initiative. Last article for today, fishery subsidy. Okay, fishery subsidy. Right, and this article appeared in Hindustan Times. So what are the points here? In the last couple of WTO ministerial conferences, one area of discussion has been fishery subsidy, because the concern has been that governments will provide the subsidies for conducting fishing, and these kind of subsidies have actually led to overfishing, illegal fishing, unregulated fishing, etc. And as a result of all of this, that is illegal, unregulated, etc., as a result of all of this, there is a danger that the population of fish in the sea might take a hit, and we might end up losing certain species of fishes. In order to control this, under WTO's ministerial conference, under WTO's ministerial conferences, for last more than a decade now, there has been a discussion regarding controlling fishery subsidies. And whenever you talk about any kind of subsidy under WTO, be it agriculture subsidy, be it fishery subsidy, the focus is on the overall amount of subsidies provided. The overall amount of subsidy. Overall here simply means the aggregate amount of subsidy that is provided by the government. For example, when you talk about agriculture subsidy, which you would have studied under the concept of a blue box, amber box, etc., the focus is not per farmer subsidy. The focus is always on overall amount of subsidy provided by the government. The same issue has been raised by Government of India now. In its report or in its filing or a document which has been filed with the WTO, India basically says no, we should not talk about aggregate amount of subsidy. Rather, we should talk about per capita subsidy. Per capita subsidy. What do you mean by per capita here? Per fisherman, how much subsidy is provided by the government? Per farmer, although that is not being discussed, but that is one of the contentions. Government of India says we should talk about per farmer subsidies as well. Because under agreement on agriculture, it is not per farmer, it is aggregate subsidy. Total amount of subsidies provided. So the argument which has been raised by the Government of India is simple. We will not support any kind of a debate, any kind of a discussion where you will talk about overall subsidies provided to fisheries sector. Why? If you talk about overall subsidy, there will be certain restrictions which might be imposed on India over a period of time. Because the amount of subsidies provided by Government of India, be it in fishing, be it in agriculture, are very high. But Government of India says, why do you talk about overall? Talk about per capita. Look at the example that has been cited by the government. If you take countries such as Norway, the government there provides $76,000 per farmer, per fisher. $76,000 per fisher. And if you compare that with India, we provide $35 per farmer per year. So argument is simple. We are providing very, very less amount of subsidies per fisher. So any kind of a negotiation, any kind of a discussion, if you introduce the aggregate subsidies in fisheries, we are not going to support it. Right? And there is a discussion, there is a deliberation. In fact, in the recently concluded ministerial conference under WTO, one of the points of debate was fishery subsidy. Although no final outcome or no agreement was arrived at, this was one of the very important points of discussion. Done? So this is an update regarding the continuing debate about agriculture subsidies as well as fishery subsidies. Now let me take up the questions that I have given earlier and discuss the key answers. Consider the following statements. The Copyright Act in India provides for fair use of copyright material. Fair use is allowed. The Copyright Act in India explicitly provides for transformative use of copyright material. Transformative usage is not allowed. It's not recognized. It is not explicitly provided under the Copyright Act in India. Like I said, it is provided, it is covered under the USA Act, but not in India Act. Right? So explicit provision is not there. Right option is only first statement is correct, option A. MCQ 42. Consider the following statements regarding University Grants Commission. UGC is a statutory authority set up in 1949. Statement 1 is wrong. Is it a statutory authority? Yes. Right, but was it set up in 1949? And if you understand why have I given 1949 here, there is a connection. I hope all of you have read the newspaper update article on this. The new RBI governor who has been recommended by Government of India is Mr. Sanjay Malhotra. I am giving you one more update. Please make a note of this. Mr. Sanjay Malhotra. He will be the new RBI governor. In fact, in today's Hindu newspaper, there is an article where the outgoing RBI governor, Mr. Shaktikanta Das, says there is always a focus on repo rate. Right? There is always a focus on repo rate. Repo rate alone cannot address the growth problem in India. Right? Earlier also we have discussed this. Rather than focusing only on repo rate, there are many other issues as well. Okay, so UGC is a statutory authority. Yes, but was it set up in 1949? No, 1956. But why have I written 1949 here? RBI was nationalized in 1949. RBI was nationalized in 1949. Okay. So UGC provides financial assistance to certain educational institutions. Yes. There are certain educational institutions which are recognized under the UGC Act under section 2 and 12, and the UGC will provide financial assistance to them. Third, UGC is responsible for the implementation of EPG Pathshala. Yes, it is responsible. What is this EPG Pathshala? It is a repository of high quality study material for many courses. Right? There are many courses for which repository is available, high quality repository at this particular platform, EPG Pathshala, and this is maintained by UGC. So second is correct, third is correct. Right option for the question will be B. Only two of the statements are true. Okay, so Manu Chaudhary says PM-POSHAN is a centrally sponsored scheme and not a central sector scheme. My dear, I think I've told you it's a centrally sponsored. If not, yes, it is centrally sponsored. In fact, I've written the split also, right? 60:40. Which basically means something has to come from the center and the remaining contribution has to come from the state. Centrally sponsored scheme. Done? Okay. So these are the important articles as well as the MCQs that I've taken up in today's newspaper, including articles from Hindu as well as the Hindustan Times. If you like this initiative, do not forget to hit the like button. And if you're yet to subscribe to our YouTube channel, kindly do it right now. That's it from my side. See you tomorrow sharp at 10 a.m. again with Hindu newspaper discussion. Have a great day.